26th. And as you heard, this is the Lawrence County Municipal Court, and I am Judge David Landefeld. I'm a retired judge sitting by assignment of the Ohio Supreme Court. This is the matter of the State of Ohio versus Philip Cook. It's 24 CRB 781. And let the record reflect that the parties are present in the courtroom. Are the parties ready to proceed?
If I may have 1 minute, Your Honor, to get the computer running, I'm ready to proceed after that. On behalf of the state.
And Mr. Cook?
Judge, I have some video evidence that I'd like to present during the case, and I need to have that uploaded onto whatever devices the court has.
I'm sorry, new evidence?
Video evidence from the date of the arrest.
Oh. All right, are you aware of this, Mr. Ashworth?
From my understanding, there's a video that it doesn't have audio but has some of the events on it. Now, I think I told this to the court earlier. That was never given to me. He has a duty to give that to me, and he didn't. I'm not going to object. He can play his video.
Okay. All right, well, we'll allow you in the defense, Mr. Cook, to do that, but otherwise, are you ready to proceed?
Judge, if I could have a minute, our recording device has malfunctioned. If I can get just a minute to correct that so that we can be on the record for this.
Should I start the countdown?
All right, I believe I've got it back on the record, Your Honor.
Very well. Mr. Ashworth, is your computer now functioning?
I believe so, Your Honor. Let me check. I'm ready, Your Honor.
Very well. Mr. Cook, you are representing yourself, and because of that, I will explain how a trial is conducted. You may already know, but out of an abundance of caution, I feel it's my duty to make certain that you understand how this is to proceed. Both parties, if they wish, may make an opening statement outlining the evidence they intend to present to the court. You may waive that, of course, if you wish. Then Mr. Ashworth will call whoever he has as witnesses to the witness stand. They will be placed under oath. They will give direct testimony. Then you will have the opportunity after those witnesses testify to ask questions of them. We call that cross-examination that needs to be relevant to whatever the testimony is. At the conclusion of the state's case, when the state rests its case, you then have the opportunity to present any evidence, and I know you want to play the video, so you can play the video at that time that you wish to present to the court. Now, you cannot be compelled to testify in this matter. You have a right against self-incrimination, but if you choose to testify in this matter, you would be placed under oath just like any other witness, and then after you tell the court what you want the court to know, Mr. Ashworth has the opportunity to ask you questions, again, cross-examine you. He may have rebuttal evidence, I don't know if he will or not, but that's it will take. Then you have the opportunity, both parties have the opportunity to do what's called a closing argument, and then the court will render a decision in this matter. Do you have any questions about the procedure?
No, but the video files that I have to present to the court are fairly large. So in order to, in the interest of time, can we go ahead and get those started to upload onto your computers?
Sure. I don't care, Your Honor. That's fine.
Okay. I don't know how. Can you upload that?
What type of media do you have it on?
Thumb drive.
Yep, I can do it.
Okay. Yeah, we'll allow that to be uploaded. Anything further?
Not that I'm aware of.
Okay. Mr. Asher, do you have an opening statement?
Briefly, Your Honor, the charge, disorderly conduct, 29-17-11, this is the charge of the first division. Briefly, no person shall recklessly cause inconvenience, annoyance, alarm to another by doing certain things. There are 4 subcategories in A1. The one that I will be prosecuting Mr. Cook on is the turbulent behavior, which has been defined by State versus Reeder and State versus Jackson as unruly conduct characterized by commotion. The facts of this case will show you that Mr. Cook approached the clerk's office in an unruly behavior, used vulgar language, loud voices, became antagonistic with staff, was asked to leave, left, then came back, rummaged through material at the security desk when the security guard was not there, knowing that that was the security desk, took material from it, and then was ultimately arrested. But those facts, which will be established beyond any reasonable doubt, establish disorderly conduct under the A1 section, and that's what the facts will show, Your Honor.
All right, thank you. Mr. Cook, do you have an opening statement?
Yes, Judge. Actually, everything that he just said will be disproven by the video surveillance. There was no commotion. I was not unruly, and my arrest was in retaliation for me exercising my First Amendment rights and my Fifth Amendment rights by the bailiffs in this courthouse. There was no criminal conduct on that date. I did not swear at anybody or raise my voice. I wasn't waving hands in the air, wasn't pounding on things. Nothing like what was described by the prosecutor will be supported by the video surveillance.
Yeah, just since we're arguing a little bit of the law, Your Honor, I do want to put on the record, since it's important, State versus Jackson, 2nd District, 1998, Ohio Appellate Lexus, 5439, Head Note 5, citing State versus Reeder, 18 Ohio State, 3D 25, 1985, the turbulent behavior provision of the disorderly conduct statute, quote unquote, does not evoke free speech concerns. Thank you.
All right, thank you. Mr. Asher, you may call your first witness.
Your Honor, I call Dorothy Bledsoe to the stand.
Do you swear the witness in, or how do you normally do that? Okay.
You solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Say your name for the record.
Dorothy M. Bledsoe.
Mrs. Bledsoe, what do you do for a living?
I'm the clerk of court here at the Municipal Court
How long have you served in that role?
since 2008. And prior to that, I was deputy clerk.
Have you been in the legal profession for any amount of time other than when you served as clerk or deputy clerk?
Yes, that's basically since I was 20 years old. I've worked at various law firms as legal secretaries and assistants prior to coming here in 2004. I started here in April of 2004 as a deputy clerk.
During your time as the clerk or deputy clerk of this court, have you come to know an individual by the name of Philip Cook?
Yes.
And is Mr. Cook in the courtroom today?
Yes.
And how do you know Mr. Cook?
I've had interactions with him at the counter initially when he had questions concerning filing an appeal from a ruling in the civil court, an eviction proceeding.
All right, and how was your interaction with him on the first occasion that you came to know Mr. Cook?
On the first occasion, I believe he had been speaking with Doreen Fox, who was the civil clerk, at the counter, and because he had questions about an appeal, and I'm more familiar with the appeal process than my deputy clerks, I intervened to speak to him, and I believe I had a packet for self-representation in the Court of Appeals. I don't know if honestly, I can't remember if I gave that to him or if I was just using that to speak to him about the process.
Are you referring to the packet that's the Court of Appeals places through a hyperlink on their webpage?
Correct.
Right, okay, thank you. And were there any quote-unquote problems with your first interaction with Mr. Cook?
No.
And after that occasion, after you had come to know Mr. Cook, did you have another occasion to be involved with him as you were serving as the clerk of this court?
Yes.
And when was that?
There were several occasions in November. I know around November the 18th, I had an occasion to speak with him.
Yeah, and on November the 18th, what was the substance of the conversation or the request that he had made to you as the clerk?
Excuse me, Judge, I'm going to have to object. I was told in the pretrial that this was only going to cover what happened on December 9th, and that I would not be able to present evidence of goings-on prior to December 9th. And all of this is history beyond December 9th. It's not direct testimony of what took place on December 9th, and that was your ruling, Judge.
Sounds good, Your Honor, I'll withdraw.
Very well.
Let's go to December 9th, Mrs. Bledsoe. Did you have an occasion to interact with Mr. Cook on December the 9th?
Yes, I did.
Tell us about that occasion.
It was a court day, so there was quite a bit of activity in the courtroom. I think it was towards the end of the docket. One of my deputy clerks was speaking with Mr. Cook at the counter, Olivia Mayo, and I believe I heard either his voice or her voice. It seemed like the conversation was a little bit loud, something that she may have needed my assistance with. Normally, if any of my clerks are dealing with someone that I think that they either need my help with as far as explaining something, or if there's a person they're having difficulty with for any reason, I usually come and see how I can assist.
And on that occasion, did you attempt to assist your deputy clerk with Mr. Cook's requests?
I did. I came to the counter and I was under the assumption that Mr. Cook had some other questions about the appeal process, perhaps, but it became evident that that was not why he was there.
What occurred during your interaction with Mr. Cook on December the 9th of 2024 in the clerk's office?
He had some questions, again, about how he were to obtain security video from the court, different parts of the court. And on a prior interaction, I had already explained to him that I was keeper of the records in the clerk's office. I was not keeper of the records or the building maintenance or security, and I was not the person to whom he should make that request. That I had asked if he would put that in writing to Judge Capper. I would find out who was responsible, and we would provide that if it were something that could be provided.
And how did he react to that information?
He was not happy. He was kind of agitated. I think he was interrupting me as I was trying to speak.
Describe for the
Objection,
court.
Judge. She thinks she doesn't know. She can't testify to what she thinks happened on that day. She has to know what happened on that day.
Your Honor, against the weight of the evidence, she can testify what she thinks she knows.
I can rephrase that, Your Honor. I know that he interrupted me at one point.
Okay. As you had the opportunity to observe Mr. Cook on that day, how would you describe his demeanor?
Well, he wasn't happy with the information that I was trying to provide. He seemed to become agitated. At one point, I said to him, Mr. Cook, I'm simply trying to help you, but you just seem to be argumentative. And at that point, he became even more agitated, and he did say an expletive, but I can't remember exactly what was said. I do know that he did say a curse word.
He said a curse word, but you don't recall whether the specific word.
No, I don't recall.
But you do recall specifically, as you reflect back on that, as you sit here on the stand today under oath, that he used vulgarity towards you as the clerk.
Yes.
Did he make any other statements to you as he continued to become more and more agitated as you explained the process for the records request?
I don't remember the specifics, so I can't speak to that, but I mean, there was conversation and he was getting more upset.
Did he ask you what you thought he was thinking at any point in time during that conversation?
Well, after I had made the statement, you seemed to be argumentative. He did seem to be offended by that, and he said that I didn't, how was I to know what he was thinking or to question what his motives were?
Was his, what tone of voice did he have? Was it loud? Was it quiet? Can you describe for the court, not necessarily just his words, but his vocality and his observations in discussing this issue with you?
He was louder than normal speech that you would just speak with someone. He wasn't screaming, but he was louder than normal, and he was moving around a bit and as if he was agitated.
Very good. And what happened at that point?
Mr. Major was in the clerk's office behind me, and when he initially cursed, he told him to, watch his language. And then, again, when it continued, he told him to cease and desist.
Mr. Major used the words cease and desist when discussing Mr. Cook's behavior with him.
Yes, I remember specifically him saying that.
And for the record, can you identify Mr. Cook in the courtroom today?
Yes, he's sitting there.
Yeah, let the record reflect that the witness has identified Mr. Cook at defense counsel table.
Very well, it will.
And as a matter of housekeeping, this all happened in Chesapeake, Lawrence County, Ohio, is that correct?
That's correct.
After Mr. Cook had been told to, quote unquote, cease and desist, what happened next?
He continued to speak up and say something, at which time Mr. Major told him to leave the premises.
And did he?
He did, yes.
What happened after he left?
When he left, and then he came back in and started rummaging through the security area, and it seemed like he picked a piece of paper, perhaps from the security area.
Yeah, let's do this briefly. The security area that you're talking about, for the record, is the area where when you enter the courthouse, the entrance is guarded by a metal detector, is that correct?
Correct.
And the metal detector is also adjacent to a podium where a security guard or other peace officer usually is posted.
That's correct.
And that podium has material and supplies on it, is that accurate?
Yes.
And from your duties as a clerk, you come here probably a lot more than you probably want to. Has it always been that way at the front door?
Yes.
Okay. Now, on this day in particular, was Mr. Major the security guard, the peace officer that was in charge of the front entrance way?
Well, he was. I honestly can't remember if we had someone earlier in the day that had left, or if we didn't have a security guard that day. But oftentimes though, he would be doing that as well as working in the courtroom. And he and Mr. Cooper, possibly would interchange in those duties.
And on this day, Mr. Major, from your prior testimony, correct me if I'm wrong, had left that post when Mr. Cook came in and came into the clerk's office, subsequently telling him to cease and desist his vulgarity.
Correct.
So he was no longer at the security desk.
That's correct. He was behind where I was standing in the clerk's office.
And Mr. Cook had the opportunity to leave and not come back after he had been told to cease and desist. He left the premises, at least from what you could tell. Is that accurate?
Yes, he had left the premises and came back in. It was almost immediately came back in.
Nobody had, at least from what you could tell, did anybody else have any interaction with him? Say, Mr. Cook, come back to the courthouse.
No.
He came back on his own volition from your observations.
Yes.
And when he came back in, he came back through the entranceway where the security guard podium was.
Yes.
And nobody was stationed there.
No, no one was stationed.
But every time he comes into the the courthouse, he would come into the entrance where the security guard station existed, right?
Correct. That's the only public entrance.
And do you have any reason to believe that he didn't understand that was a security post?
No, I mean, I can't imagine.
And as he came back in, what did he do? He rummaged through the courthouse's supplies and material at the podium of the security post.
Yes.
No, did anybody tell him to get in that area?
No.
And what was he doing there?
I remember stating, well, what's he doing? He's taking something, and it appeared that he took a piece of paper and possibly a pen or something that looked like a pen.
And what did he do next?
He left.
He left back out of the courtroom again with the stuff that he had just taken from the security podium?
Correct.
And then what happened?
Mr. Major and Mr. Cooper followed him outside.
Dorothy, has Mr. Cook told you to watch your back?
He's not specifically told me that, no.
Has he ever said anything to you that you have perceived as a threat at any point, not just on December the 9th, but at any point?
Well, he's just made statements that are concerning when asking for security video of the judge's chambers and leading from the area where the attorneys meet in the conference room to the judges, wanting video and that. And then on the telephone when he's made
Again, Judge, I'm going to renew my objection. What happened on December 9th happened in this courtroom, or in this courthouse. It did not transpire on the phone. It was not, there were no phone conversations on December 9th between myself and the courthouse of any kind. And this is going into evidence, information that I wish to bring forward that you denied me because I wanted to bring information that preceded December 9th. And now they're introducing evidence and testimony of what may have happened prior to December 9th.
Your Honor, I would ask that the court consider it for the limited reason of after I convict Mr. Cook of this, I'm going to ask for protective order. I think the court can separate this testimony from the circumstances of December 9th. I didn't want to call Dorothy back to the stand.
This is prior or subsequent to December 9th?
I believe it was subsequent to.
I'm going to overrule your objection, Mr. Cook. This is subsequent to the 9th, and it may have information regarding what occurred on December 9th. So you may proceed, Mr. Woodson.
Judge, then in that case, I'm going to ask for a continuance so that I can produce my phone records, because I can show that subsequent to December 9th, I never called the courthouse.
I don't believe she testified he called. I believe she's talking about statements he's made. He's been here plenty of times, Your Honor.
She said on the phone.
The record will reflect what her testimony was.
I'm going to allow it. You may proceed.
He did ask on the phone if our phone conversations were recorded here, and I said no, and he said, we'll see about that.
Very good. Can you tell the court any specific language that he's used that has caused you concern from a potential physical harm standpoint? And if none, say none, that's fine.
I mean, not particularly, no.
Very good. Now, just for the record, Mrs. Bledsoe, today is February the 25th of 2026. In the last 45 days, you've had a heart attack?
Yes, correct.
Okay, and I bring that forward because I'm going to ask the court to make sure that you're not handled inappropriately on any cross-examinations. But with that being said, I pass the witness, Your Honor.
Very well. Mr. Cook, at this time, you may ask Ms. Bledsoe any questions on cross-examination that you have.
Okay. Ms. Bledsoe, first I'm going to start out with, are you aware that perjury is a criminal offense in the state, punishable by up to 3 years in prison and a $10,000 fine?
I would never perjure myself on the stand.
That's not the question I asked you, ma'am. I asked you, are you aware that perjury is a criminal offense in the state that is punishable by up to 3 years in prison and a $10,000 fine?
I'm aware that it's a criminal offense, but I did not know the penalties.
Would you take it as my word at this time that it does carry a 3-year jail penalty and a $10,000 fine?
No, I will not take it at your word.
Judge, at this point, I'm going to motion for a mistrial and a dismissal for cause because there are at least 2 material fact witnesses to what transpired on December 9th in the courtroom, Mr. Major and Mr. Cooper. Their testimony has been irretrievably tainted by the testimony given by Ms. Bledsoe, and I don't believe that they could be rehabilitated. You issued a gag order back in March of last year to prevent witnesses from being able to speak to one another. That was to prevent them from being able to coordinate their stories. And having them in the room while the testimony is taking place does the exact opposite of what your gag order had intended to do. They witnessed the testimony from Ms. Bledsoe. Now they know what they can and can't say to corroborate what she says.
Your Honor, first of all, your gag order was applied to them speaking with each other, which they have not done. He's more than welcome to sequester the witnesses, and he didn't ask the court for that. He's playing the fumble here. Obviously, I please ask that all of those motions be denied.
Yeah, Mr. Cook, if you're asking for secrets that the witnesses be sequestered, that should have been done before Ms. Bledsoe testified. I'm not telling you how to try your own case.
Okay.
You had that opportunity. You didn't take that opportunity.
That's fine.
I'm going to overrule your motion for a mistrial. There is no indication that anything has been done improperly. So,
Well, I would like to motion that they be sequestered at this juncture.
No objection?
who are we talking about here?
Your Honor, we have Mr. Major, who's leaving the courtroom, and then we have Mr. Cooper, who will also leave the courtroom. They would be the state's witnesses here.
Very well. That motion will be granted at this time.
Your Honor, I'll turn off the speaker system.
Very well. You may continue your cross-examination,
Okay.
Mr. Cook.
Ms. Bledsoe, are you now or have you ever been an attorney or a judge?
No,
So you have no legal training to be able to make judgments on what is and is not lawful. Is that correct?
not as an attorney or a judge, no. I mean, I've had training through the Clerks Association and seminars and such for what
Is appropriate for a
for
clerk?
training in the clerk's office, but not as a judge or an attorney, no.
Okay. Have you ever engaged in any kind of misconduct or illegal conduct while you've been in your office?
No.
Judge, I'd like to present this email at this time, being proffered to impeach the testimony of the witness on the stand. This is an email from November 12th of 2023, or 4. November 20th, 2024. And this was in the discovery packet that was given to me by Philip Hill. He should already have this email.
Well, he already has to do it right, but he needs to mark it, he needs to introduce it, he needs to move for it to be admitted.
Well, let's identify it. Do we have defense stickers, and we'll call this Defense Exhibit 1.
That's fine, Judge.
And Mr. Ashford, you have seen this?
Yes, Your Honor. It's actually, this has been filed, it's actually stamped, and it's in the court file.
All right.
And Judge, if I may, I didn't think to do this, but could I get a photocopy of that before we leave
Well,
today?
why don't you present it to Ms. Bledsoe so that she can review it, and then you can ask her questions about it?
Absolutely.
Isn't that what you want to do?
Yes.
Again, I'm not trying to tell you how to run your case.
Ms. Bledsoe, if you could read that and let the court know when you're finished, I would appreciate it.
You want me to read the entire?
Yes.
Well, I'm going to object then, Your Honor. He's already made this motion earlier that we're not talking about anything other than December the 9th, and now he's trying to get Mrs. Bledsoe to read an email from a different date about things that occurred on dates prior to December the 9th. So if we're going to stick with his way we're handling this case, then objection.
This is being proffered to impeach the testimony of the witness on the stand.
I'll allow some limited testimony here.
Okay, this is an email from myself to Summer Sullivan and Corey Watson.
And ma'am,
Commissioner's office.
I'm not asking you to read it aloud to the court.
Oh, okay.
Are you ready? Okay. Judge, permission to approach so I can grab the document.
He'll get it for you.
Ms. Bledsoe, a moment ago, you testified that you have never engaged in any kind of misconduct or criminal conduct while in the employment as a clerk in this courthouse, correct?
Correct.
Okay. Can we agree that based on this email, that I called on November 20th to request video surveillance?
Correct.
We agree to that, correct?
Yes.
And you stated in this document that you would not be granting my public records request. You said that you were denying my public records request, correct?
Objection, relevance, we're not on December the 9th again.
That's not what I said.
You can respond, Ms. Bledsoe.
I did not state specifically what you said.
You stated, I told him I wouldn't take a request on the phone and he would need to put it in writing to Judge Capper and that we would forward it to our legal authority.
That's correct.
So you refused to take my public records request over the phone, correct?
Correct.
Okay. Are you aware that state law explicitly says that public records requests can be made in any format whatsoever, totally subject to the requester's desire?
Objection, Your Honor. This doesn't justify him being disorderly if it's yes or no, so it's irrelevant.
Judge, it goes to impeach the testimony and it shows misconduct by Ms. Bledsoe.
There's no misconduct in this case except for him.
Interference with rights under the color of law and practicing law without a license are both illegal acts in the state.
So he can act disorderly because he thinks she violated his sunshine laws? That's not what we're here for.
Judge, it's going strictly to impeach her testimony.
Which he has not
Okay,
done.
I think you made your point,
Okay.
Mr. Cook. You may move on.
Okay. And if I recall from your statements, you said that you didn't know why I was here on December 9th, correct?
Correct, I walked up to the front and I wasn't sure why you were here.
Do you recall me saying anything to the effect of, I was asking for a way to file a formal complaint against you?
I don't remember you saying that, but I did, I was informed that by Ms. Mayo.
So you do know that I was there for the
Yes.
purpose of,
After the fact, I knew that that's why you were there, to file a formal
Af-
complaint.
okay, so after the fact. So do you recall telling me that if I wished to file a formal complaint against you, that I could file a grievance with the Ohio State Supreme Court's Office of Discipline while we were both in the clerk's office?
I do not remember telling you that. I don't believe you would file a grievance against a clerk there. You could file a grievance against a judge. You would file a grievance with my boss, who was Judge Capper.
Right, but if I told you that you said that I could file a grievance against you with the Ohio State Supreme Court, do you have just cause right now to tell me that I...
Objection, asked and answered. We're not doing each question 2 or 3 times, Your Honor, are we?
She answered your question, Mr. Cook. She said that if you wanted disciplinary action filed, it would be against her boss, Judge Capper. I believe that's been asked and answered, so let's move on.
Okay. And you testified that, if I recall correctly, that I was, let's see, that I cursed numerous times in the courtroom, in the clerk's office after Mr.,
I didn't say numerous times. I remember a couple. There was once before Mr. Major asked you to cease and desist, and then you said something afterwards, and that's when he said, "All right, leave."
but you don't recall what that word is.
No, I don't.
If I was to tell you that the word that I used was the word hell, would you disagree with that?
I mean, I would neither agree or disagree because I don't remember it. It's been over 1.5 years, and I don't remember the specifics.
Have you ever heard of a Supreme Court case called Cohen versus California?
No, I have not.
Okay. And again, you're not an attorney and you're not a judge and you're not a law enforcement officer either, are you?
Correct, I'm neither of those.
If I was to tell you that California versus Cohen was a decision in 1971 that said that vulgar language in a courthouse is protected free speech, would you have reason to argue with me?
If you were directing that to my person, yes.
Explain that. I don't understand what you meant there.
Well, if you were cursing at me or you were directing that to the members of my staff, yes, I would say that you could be asked to leave the courthouse. We even have a sign in the clerk's office that says you can be asked to leave for that, or it may not specifically say that, but
Was that sign present before or when this interaction took place?
yes, it's been there for quite a while.
So you allege that I came in, I was immediately loud and disorderly,
I don't know, I'm sorry.
meaning that I was being verbose and speaking in a loud volume from the time that I entered.
I don't know because I wasn't there from the time you were entered. I was back in my office. On court days, I'm frequently traveling between my office and up front assisting at the counter. But at some point, I heard your voice and I came to the front to assist Olivia to see if she needed help or why you were there.
But you don't recall the fact that I was there to file a formal complaint against you?
Asked and answered.
I didn't know that at the time.
Okay. If I told you that that was the first thing I said to her when I showed up at the window, You have no reason to disagree with me, correct?
Correct.
Judge, at this time, I have no further questions for this witness. However, she is subject to recall.
Very well. Mr. Ashworth, any further?
Yes, Your Honor. Where is defendant's exhibit? Is it A or 1?
1.
Where is that at?
I think he has it.
Can I approach the witness, Your Honor?
Yes.
Mrs. Butts, I'm going to hand you what's been marked defendant's exhibit 1. There are 3 paragraphs. The second paragraph, I'm going to read it. Let's make sure this is your language. His behavior in person and on the phone causes concern that he is not mentally stable, and I wanted to bring it to your attention. We don't have a security guard on non-court days, and John Mayer's leaving for vacation tomorrow. When Josh Cooper is in the office, there's no one monitoring access to the building. Years ago when I first started, we had a panic button at the front desk that called the sheriff's department, and then you asked questions about whether you could get one placed there again. Are those your words?
Yes.
Would you agree with me that your interactions with Mr. Cook has caused you annoyance and alarm?
Yes.
No further questions.
Any recross?
Actually, yes, if I may have that back, please. In the first email, do you see where I stated that, or where you stated that I was investigating Brian Cremines for misconduct?
Your Honor, can you hand the witness the exhibit if you're going to ask her questions about it?
Could you?
Go ahead and ask your question, Mr. Cook.
Towards the end of the first paragraph, do you see where where you stated in the email that I was compiling evidence of misconduct against Brian Cremines?
Well, I stated that you were a defendant in an eviction case that had been concluded, but continued to file post-judgment motions for relief that Brian has been addressing. Would you like me to read this?
Yes, please.
He filed an indigency affidavit for a free transcript for use in a court of appeals action, but Brian denied that, and I don't think he wants to pay for a transcript, so is now redirecting his energies to compiling a complaint against Brian for judicial misconduct.
So that would entail me asking questions about Mr. Cremines' conduct. In order to file a grievance, I would have to have some kind of evidence to do so. Would you agree with that?
Yes.
Okay. So can we agree that after the eviction proceeding was over with, I was asking questions specifically about Brian Cremines and the way he conducted business in this courthouse?
You didn't specifically ask me, no.
Okay. Based on what was read in the email, can it be inferred, or can you state that I was looking for misconduct against Brian Cremines?
The reason I stated that is I felt that in the video that you were requesting, and a conversation that I heard you have with Mr. Major over the phone, you were asking questions about, do the attorneys speak with the judge before court hearings? You were asking questions like that, which made me, it was my opinion that that's what you were trying to do. As you were thinking that the judge was speaking inappropriately to the attorney that represented you in the eviction case, and that you were going to file some sort of grievance or complaint for misconduct for ex parte communication.
Are you aware?
That was my opinion.
Okay. So I was asking questions about Brian Cremines.
Yes.
Okay. Do you know, is it legal, lawful, or protected for citizens to investigate government officials for potential misconduct?
Objection, I've let this go for a while, Your Honor. We're not on December the 9th anymore. This is his objection, by the way. I'm just repackaging it for the court.
Mr. Clerk, I don't understand what your point is here. Why are you asking this question?
Because she alleged in the email that I was somehow off my rocker when I was asking questions about the way that Judge Kermeans conducted his business as the judge in this courthouse, which is a constitutionally protected activity to be able to investigate your government officials for misconduct.
Misrepresentation of the evidence, for the record.
Mr. Cook, I don't think that's what the email says.
Okay.
But I read it. I don't know that there's any more information you're going to get regarding this interaction. Again, we were trying to talk about the 9th, and I think I've gotten a sense of what's going on here before December 9th. So let's move along if you have any other questions regarding, and again, that they're limited to the defendant's Exhibit 1 at this point.
On December 9th, you said that I was making a commotion, correct?
Wait a second. Are we talking about Exhibit 1?
No, December 9th.
Well, it's outside the scope of redirect.
You've already had the opportunity, on cross-examination to ask about December 9th.
Okay.
On redirect, Mr. Ashworth asked specific questions about defendant's Exhibit 1. You are limited in your re-cross-examination to those matters that he brought up on his redirect. If you don't have any more questions about that, then...
That's fine. Subject to recall.
All right. Ms. Bledsoe, you may step down.
I'd ask the witness be sequestered, Your Honor, in case she's recalled.
Very well.
Call Mr. Major to the stand.
Mr. Major, please raise your right hand. You solemnly swear that the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name for the record, sir.
John Major.
What's your current occupation and profession?
I'm a probation officer for the Lawrence County Municipal Court.
How long have you served in that role?
Since 2017, so it's going to be almost 8 years.
What did you do before that?
I was a Lawrence County Sheriff's Deputy,
How long?
17 years.
A pot of trade?
Yes, sir.
Where at?
At the Lawrence County College Career Center.
Okay. 1 year at the police academy then?
Yes.
Graduated in what year?
2000.
Been in law enforcement since then? Continuously?
I have.
Okay. Have you worked, what type of roles have you had as a sheriff's deputy?
I've been a dispatcher, a road unit, and a corrections officer.
You've done it all?
Mm-hmm.
Is that a yes?
Yes, sir.
And what duties and responsibilities do you have at the Lawrence County Courthouse?
I'm the probation officer. I oversee the individuals being convicted and placed on probation. I'm also the head of security, so if we do not have any security at the front of the building, I am to either work it or assign somebody to work it.
And explain for us the security at the head of the building that you just mentioned.
At the entrance of the building, we have a metal detector and a X-ray machine, so everybody has to come through, empty their pockets, put anything that's in a bag or something through the X-ray machine, and once they go through the metal detector, if it goes off, we're subject to some sort of a external pat-down.
There's some type of podium or other stand out there?
There is a sort of desk that separates you from the metal detector and the people coming into the building.
Is that desk property of this, is it assigned to the security department?
It is.
It's property of the courthouse, I take it?
Yes, it's property of the courthouse.
Does anything say that it's community property or open to the public?
It does not.
Did you come to know a gentleman by the name of Philip Cook?
I do.
And can you tell us if he's present in the courtroom today?
He is. He said it at the defendant's table.
And let the record reflect that the witness has identified Mr. Cook at the defense counsel table. How did you come to know Mr. Cook, sir?
Just through his interactions at the courthouse, through previous interactions.
Very good. So we're trying to limit our testimony to December the 9th, but briefly, can you confirm or deny as to whether you've observed Mr. Cook go through the security portal at the front door prior to December the 9th?
He has.
Did you come to have an interaction with Mr. Cook on December the 9th of 2024?
I did.
And tell us about that.
So I did not have a security officer to work the front entrance on that date. It was a court date. So I was working it. Mr. Cook entered the courthouse, went through security as he is supposed to, and entered into the clerk's office. Without going into too many details, knowing some history on Mr. Cook, I followed Mr. Cook into the clerk's office and just kind of stood by and just watched to make sure he was not being out of.
Okay, so if I understand you correctly, on December the 9th, Mr. Cook entered the front entrance of the courthouse. You then escorted him through the security as you do anybody else in a normal manner, and he passed the security challenge and was allowed to go on his way into the courthouse, at which time he went to the clerk's office, and you followed him because you were concerned about potential issues that may arise there.
That is correct.
Okay. And what happens when you get to the clerk's office at that point in time?
I go on into the clerk's office. He's in like the breezeway area where the civilians or the public will stand and talk to the clerks. He was talking to the clerks about stuff. I don't remember what exactly he was talking about. And he was being in a normal manner. At one point, Ms. Bledsoe comes out and is talking to him, and their conversation, I'm not paying attention to it at this time because he's not elevated anything to pique my interest in him and be out of line. At one point, the interaction becomes a little bit more heated. I'm not sure exactly what Ms. Bledsoe says, but Mr. Cook says this is bullshit. And at that time, I advised Mr. Cook that type of language was not going to be tolerated in the courthouse. He became more agitated. Body language changed. I wouldn't say his arms were flailing, but he became more animated.
Okay, let me stop you there for a second. So, just to make sure I understand your testimony, Mr. Cook, in your presence, said bullshit in response to some information that's being passed to him by the clerk of the court. Is that accurate?
That is correct.
Okay. And is that appropriate in your court, sir?
It is not.
And as a result of that, what did you tell Mr. Cook?
I told him that language would not be tolerated, and then he proceeded to become more agitated.
So in other words, you didn't arrest him for saying bullshit. You didn't tell him to leave. You just told him to settle down, more or less.
Yes.
And in response to that, he became more animated, I believe you said.
Yes.
Now tell us, from a good 25 or 30 years, my math is not good, so I went to law school in law enforcement. What type of observations are you witnessing from Mr. Cook that sets your, what we call in the military, atmospherics off about his demeanor?
He's becoming louder. His more movements, stiffening of the body, just indications that he's become more agitated and more concerning to maybe become more violent.
Objection, Judge. There's no allegation that I was violent in any way, shape, or form during this encounter.
He didn't testify he was.
You just said become more violent. That
Yes.
insinuates that I was violent and there was a potential escalation of violence. Nobody,
Okay, Mr. Ashworth, what's your response?
That's fine, Your Honor. I'll agree to withdraw that. Let me rephrase that. Would you agree with me that he became turbulent?
Yes,
Did he become more turbulent after you told him to cease and desist?
he did.
Okay. Did he cause a commotion?
He did.
What happened after you noticed that he was now turbulent, causing a commotion? Did he again curse?
When he became more turbulent, I advised him to cease and desist, and that even made him more turbulent. And that's when I told him he needed to leave the premises.
Okay. Did he cuss or use vulgarity on one occasion or more occasions?
That is as of nothing, not testifying anything prior, that is the only time he cussed in the courthouse on that day.
Okay, so there was one instance, you responded with a cease and desist. He then became what you believe to be more turbulent than he had been before, and you asked him to leave. And is that a yes?
Yes, I'm sorry.
And what happened at that point in time?
He didn't immediately leave, but he did leave within a matter of time that I felt like that the situation was going to be over, and exited the front of the courthouse.
And if he would have stayed gone, did anything happen that day?
No.
But what did happen after that?
I want to say within a minute, Mr. Cook entered back into the courthouse through the entrance.
Is there a security guard at the entrance at that point in time?
There is not. I have not made it back to the entrance.
What's significant about a person being asked to leave a courthouse and then returning within 60 seconds?
It piques my interest to possible violence.
In other words, potentially when I got something out of the car would be a concern that you as a police officer with 27 years of experience would have when a person leaves the courthouse being asked to and then returns when he knows or should know that he shouldn't be there.
That is correct.
All right. Did anybody tell him to come back?
I'm sorry?
Did anybody tell him to come back?
No, not to my knowledge. Nobody at the courthouse told him to come back.
Did you tell him to come back?
I did not.
What happened after he came back?
He started rummaging through the security desk. I then approached, at one point, Mr. Cooper came out. In order to not have a physical altercation with him, I did not interact with him at the time. I waited him to complete what he was doing. At that time, he appeared to be writing something down on a piece of paper. As he finished, he didn't throw something at the paper at me, but he didn't hand it to me neither. And then he turned to leave. At that point, I advised Mr. Cook that I needed to speak to him. He continued on. I then advised Mr. Cook he was not free to go, that I needed to speak to him. And he continued on, ignoring my orders. I exited the courthouse with Mr. Cooper, and I advised Mr. Cook to stop, that he was placing him under arrest.
Okay, very good. So in other words, when he returned, in your experience and your training as a law enforcement officer, that would potentially qualify as trespass.
Correct.
And when he rummaged through a security portal that's not public property, that would potentially be considered for investigation for theft.
Correct.
And he in fact did take things from the security portal.
Correct.
And you didn't know exactly what they were, but they were material things.
Yes.
And was that also the fact that he had came back in, trespassed, and began rummaging through a security portal that he should not be access to? Was that causing a commotion?
It was.
And has Mr. Cook attempted to influence or intimidate any of your testimony here today?
At one of the last hearings, I don't know if it was the last one before, he did approach my office and he started talking about that he was going to, that if I was happy with violating his civil rights and that he was going to be pressing charges on me, putting me in prison, just stuff that I didn't really pay much attention to him. I just advised him that he wanted to ask me some questions. I advised him that I'd answer any questions he had while I was under oath.
Very good. Thank you, sir. I have no further questions. The state will pass this witness.
Very well. Mr. Cook, cross-examination.
So, I want to go back to your testimony a little bit. You were not in the clerk's office at the beginning of the conversation when I started interacting with the clerks, correct?
I couldn't say. I followed you in. I don't know if you would start talking by the time I got through the security door into the clerk's office or not.
Was I already engaged in a conversation with Miss Mayo when you entered the clerk's office?
It's over a year ago. I'm be honest with you, maybe. I don't know.
Okay. And so, you said that I was animated. Can you describe what animation means?
More movement of the hands, more stiffening of the body. It's animated. It's just louder in your voice.
Moving around?
Moving your hands around more than normal people.
Kind of maybe pacing around a little bit, or?
Well, that's your version.
I'm asking you.
That's not what I said.
Okay, so I'm moving my hands.
Moving your hands, body language, stiffening of the upper body, stuff like that. Yes.
And based on your experience with people, do some people speak with their hands?
Yes.
So some people just, as a normal part of conversation, are more hand mobile, correct?
Yes.
Okay. So that in and of itself doesn't indicate any kind of agitation, does it?
Can.
Can. We're not talking about can, we're talking about does.
No, we're talking about whatever the witness says we're talking about.
So the only things that you can point to is that I was moving my hands around and I became stiff.
No, you became louder.
Okay.
You became, your voice became louder. You stiffened up in a defensive posture. You became more. Your hands became moving more.
Okay. And so you said that I said the word bullshit.
Mm-hmm.
Is it possible that I said the word hell or bullshit?
No, it's bullshit.
Okay. And do you recall, so immediately before I cursed, okay? Do you recall me telling Miss Bledsoe that I just tried to get you guys to follow the law?
No, I do not.
You don't recall that?
I do not.
Okay. And do you recall her saying that she just thought I was here to be argumentative?
No, I do not.
Okay. And if I was to tell you that she testified to that earlier, that she said that she felt that I was here to be just argumentative.
Objective form is not the representation of the testimony.
If I was to advise you that she testified to that fact, that stipulated that fact, that she said that I was here, she thought I was here just to be difficult or disagreeable. Can you say that that's a lie?
The objections calls for speculation. He said he didn't know what she said.
He can testify to what he knows.
Okay.
Or what he saw, what he heard, what he smelled, what
Okay.
he tasted.
And so you said that you ordered me to cease and desist, and then you ordered me to leave the building because you said I became more agitated, more animated.
Mm-hmm.
Okay.
Yes, sir.
And did you point for me to leave the building?
I did.
Okay. And so, do you recall me asking you immediately after that if I was being told to leave because I said a curse word?
I don't remember you saying that, no.
Okay. Excuse me. If I was to tell you that you said that, would you have reason to call me a liar or disagree?
I wouldn't know either way.
Okay. Are you aware that cursing in a courthouse is constitutionally protected?
Objection, Your Honor. This is not even accurate.
I'm just asking him a simple question.
Your Honor, we're here on an A1 charge. I've read the court, the law. It's Ohio State black letter law. This charge has absolutely nothing to do with protected speech. That's black letter from our Supreme Court. The A1 violation of tumultuous behavior for unruly conduct causing commotion has absolutely nothing to do with freedom of speech.
And
Go ahead, Mr. Cook.
And I disagree with the characterization, and I'm trying to get to the fact that I was told to leave the building because I said a bad word. And that's what I'm trying to draw out now.
I think the record and testimony reflects he was asked to leave for a series of things.
I'm going to sustain the objection, Mr. Cook. The freedom of speech, as Mr. Ashworth has stated, is not going to be a part of this charge. It's not a defense to the charge of disorderly conduct in this instance. But go ahead.
Are you aware of whether or not there's video surveillance in this case?
There was.
Was it furnished to the court or to the defense?
Yes.
Was it furnished to the prosecution?
Well, hold on. What prosecution? I'm not the prosecutor's office. I know this is hard. I'm certainly not being antagonistic to Mr. Cook. When I have a conflict with the prosecutor's office, I am the investigator, the records custodian, the paralegal, the attorney, soup to nuts, as they say. So when you say this, the prosecutor's office have it, that's a conflicted office that I'm completely siloed from. I don't even call them to ask them for stuff, even for a template. So I want to make sure that that's clear, that when he says, was it provided to the prosecutor's office, it might have been, that's just like saying, was it provided to some other attorney? It wasn't, I'm not that person.
What you're saying is you did not provide any video?
I never got this video. And I think Mr. Cook will actually admit that I told him that. We were here. I said, I've never gotten the video. I said, you actually have a duty to give it to me. The video, as Mr. Cook knows from his court of claims actions, records over itself on certain median days go by, because that's how these systems work. So by the time December 9th goes to March or April of the next year, and that's the first time I even knew this case existed, there was no video that I could get. Now, Mr. Mulford, his prior attorney, has it, but as you can imagine, Your Honor, he doesn't want to give me anything, because there's some other thing going on now with them. So I don't have a video. He can play his video. I know it exists, but to ask, I just want the court to be sure, and he's more than welcome to introduce it to evidence that the other prosecutor's office had it, but I don't have it.
Judge, I also have evidence that he was provided it.
I still have it.
Okay, well, there is a video. You're going to be permitted to play it, so I don't know what the relevance of the question you're asking Mr. Major here regarding it has to do with anything.
Well, Judge, my contention is that I was not disorderly pursuant to the statute, and that I was ejected from the building because I said a dirty word. And video surveillance will bear that out.
Okay.
And that's why I was asking Mr. Major if he is aware that it is perfectly lawful to say a curse word in a courthouse.
It's not an accurate representation of the law.
That's not an accurate representation of the law, Mr. Cook.
It's representation of Cohen versus California, a Supreme Court decision that limits what can be considered disorderly conduct.
Well, the court will take that under consideration, but please move along.
Okay. So you stated that I left. How long was I gone before I came back?
A Less than a minute.
So there was no concern that I went to my vehicle. I was literally left the doors, walked outside, stood out there for a few seconds, and then came right back in.
Most definitely there was a threat that you may have made it to your car.
Okay. When I entered the building, did you see anything in my hands?
No.
Okay. When I entered the building, did I raise a commotion?
No.
So what did I do specifically?
The commotion, you did not raise a commotion, but you were rummaging through a security desk that houses weapons.
Is there any way for me to know if it has weapons?
I don't know.
Okay. Did you see me pull any kind of weapon out? Did you see any kind of weapon in my hand at all? At any point?
No.
Okay. And what did you see in my hand?
When I got out to the security post, you had a piece of paper and a pen.
Okay. And are those regularly considered to be dangerous objects?
In my line of work, yes.
For the normal public, is a paper and a pen, and what, so I had a paper and pen in my hand. What was I doing with that piece of paper and pen?
You were writing on it.
Okay, is that a dangerous act does that, so I had a piece of paper and a pen that I was writing on. So, did you determine at that moment that I was not engaged in any kind of hostile or aggressive conduct towards anybody?
Not alleging you was, Your Honor.
No.
Okay? Are you familiar with public records law in this state?
No.
You're not? Okay. Are you aware that public records law states that access to public records is a right?
I have no idea what the public record laws are.
Okay. Are you aware that your order to leave the building, let's say that what you're stating is absolutely correct, and this is the way things happen, okay? Are you aware that your order to leave the building cannot act as an interference to the rights of the person you eject from the building?
Objection, he doesn't know what he's talking about. That's not an accurate statement of the law. You don't get to come in and cuss the clerk out and then be asked to leave and say, no, I have a right to be here.
Mr. Cook, that's not an accurate statement of law, but to sustain the objection.
Okay. Can you give a person an order that would interfere with their rights?
Yes.
Okay. And could you tell us what kind of orders you can give people to interfere with their rights?
Without a scenario, I couldn't tell you.
Okay.
There are, I mean, I have placed people in jail that is interfering with their rights.
Okay. Okay. So, I was writing on a piece of paper. Did you have a chance to read that piece of paper?
I did not.
You never read it?
No.
I'd like to provide this to the defendant, or to the witness, please.
Are we going to identify that?
Yeah, Exhibit 2, Judge.
Okay, so this is a document that's going to be marked as Defendant's Exhibit 2, and Mr. Ashworth, I don't know if you have it or not.
I probably do, Your Honor, but I probably should take a look
It's a
at it.
handwritten, appears to be a handwritten,
To Judge Capper at the top.
Judge Capper.
I have it, Your Honor.
You have that?
I do,
Very
sir.
well.
Yes.
Let me hand that to the witness.
Can you go ahead and read that to yourself?
No, because I have my glasses with me. But I'll take your word of what it says.
Judge, if we could make he said he can't read it because he doesn't have his glasses with him. If we could take a brief recess so he can get his glasses.
You need readers?
Deputy Barker, would you ask Mr. Bell? Yes, I need reading glasses. I did not bring them with me.
I got 175s if that helps.
That's what happens when you get old.
Yep. I can't read it now, yes, give me just a second. Okay.
Okay, are you, so, want to ask you a question about the video surveillance and the way that the video surveillance in this building works. Every 31st day, the oldest day falls off of the server, is that correct?
Somewhere around 30 days it records over, I don't know exactly the date.
Okay, but there's an age-off date that's
There
right
is.
around the 30-day mark.
Correct.
Okay. And what does that document, what am I trying to do with that document?
Try to obtain, looks like some type of surveillance video.
Okay. Are you aware that under public records law, I have a right to request video surveillance?
I don't know anything about the laws. The public's right to have those laws.
Okay. If I was to tell you that that state statute makes it a right that people can request public records, would you
One
ever?
people can request public records. I don't know what statutes say they can, what they can and can't have. That's not my job.
I'm aware of that. I'm trying to convey to you, or trying to get from you, that that is a request for public records, yes?
Yes.
Okay. And to the best of your knowledge, you don't know whether that's a right that the people have or not?
I know they have the right to public records.
Okay, so we do, okay,
I
good.
don't know the laws, but I know they have the right to public records.
So then it is a right to request public records, yes?
I would assume so.
Okay, and had I left for the day and come back, video surveillance that I wish to have access to could possibly have been destroyed by age off, correct?
Objection, speculation.
Mr. Cook, are you saying with it, at 30 days, it's automatically taped over?
Yes, Judge.
If that's the question you're asking, I think he can answer that. If he
So,
knows.
the age off is at the 30-day mark.
Somewhere around there, yes.
Okay, and had I not made that request on the date that I made it, the date in question, then video evidence may have been lost or destroyed by virtue of the system not having enough memory.
It would have been written over after 30 days.
Right, so that was a time-sensitive request with the court,
Could have been. Okay.
okay? So do you think that your order to leave the building can prevent me from making time-sensitive requests with the court?
No.
No, you
No.
don't think
I
that?
don't believe that.
So what you're saying is that despite your order to leave, I have a right to demand records, request records, so, especially in the event that I know that the records are subject to deletion.
What I'm saying is that your order to leave that day is not going to hamper you from getting them records, is what I'm saying.
However, had I left, we can both agree, based on your testimony, that records would have been deleted.
No, objection. That's not what he testified to.
That's not, you're mischaracterizing his
Okay,
testimony.
so, does somebody go in and delete records?
No.
The system has an age off itself, correct? Okay. So if I come in here, and let's say it's a 30-day mark, okay? Let's say it's 30 days. If I come in here on day 30 and request the last 30 days of surveillance,
Okay.
okay, that 30 days would be there. So let's say it was today, so 30 days ago would be January 27th-ish, okay? But if I left and didn't submit that request, and I had to leave and be gone based on your orders, then I would have lost days of video surveillance that I wanted access to.
All right, I'm going to object. This is relevance, first of all. Secondly, do you not have a fax machine? I mean, it's not like you can only deliver this personally, or this is silly. Irrelevant. Calls for speculation. It doesn't have anything to do with the case. You still don't get to act disorderly.
One, I was already here. Two,
You were asked to leave, though, according to testimony here, Mr. Cook, so I I'm going to sustain that objection because you are asking the witness here to speculate as to what may have happened, what may not have happened.
Well, no, Judge, I'm trying,
We're trying to
I'm
figure out
sorry.
what did happen.
I'm trying to get from the witness a fact question, not a speculation. Based on if video surveillance automatically deletes, okay, then video evidence that I wanted access to would have been discarded had I not made the request on the day I requested it.
It wouldn't have been discarded for 30 days.
I had,
Right?
so the request that I made was for the last 30 days of video.
He would have lost a day if he didn't do it that day. We'll stipulate to that, Your Honor. The problem is, he's acting like he can't mail it or fax it or have somebody else bring it to the courtroom. He acts like this is the only way it could have happened, and that's the disconnect from testimony and his question.
And according to state statute, according to 149, public records requests can be made by any person, by any means that they wish, verbally, in writing.
It doesn't let, on stolen paper after disorderly conduct is not in the statute.
I think what Mr. Ashworth is talking about is the manner in which a request is made. I think it has to be done such that no one feels threatened or.
Well, and Judge, I will go back to the email from Ms. Bledsoe that she testified to. Actually, Judge, I would like to present that email.
I've got the email here.
Oh, I'd like to present that to Mr. Ashworth, to the Mr. Major.
Very well. This is Defendant's Exhibit 1.
Okay?
Can you read that to yourself, please? And actually, you only need to read like half of the first paragraph.
You can read the whole thing, witness.
Okay.
Do you see in that email where she told me in the first paragraph that requests for video surveillance would have to be made in writing?
Okay?
Okay.
Yes, I do.
So I was following her instructions as to how to go about getting the video surveillance.
Objection.
The prosecutor
There's
asked,
testimony that that's what, well, first of all, you'll have to establish through testimony other than the witness here of what was going on with Defense Exhibit 2. He didn't see Defense Exhibit 2, I take it, before today?
Your Honor, that's the paper he gave me, and it went directly to the prosecuting attorney's office as evidence in the case.
Okay.
Wait, what,
His testimony is he didn't read it.
Yeah, I did not read it.
So, there you go.
okay. But we can agree that I made a public records request, yes? That's what the paper said.
At this time, reading it here, yes, that was
Okay,
public.
and we can agree that Ms. Bledsoe had previously informed me on November 20th that request for video surveillance would have to be done in writing.
According to that paper you gave me there, yes.
Okay, so I was complying with the manner in which the prosecutor said, can't we do this by fax, can't we do this by these other methods? I was told to do it in writing, and that's what I did, correct?
You guess.
Okay. I'm going to ask you the same question I'm going to ask that I did ask Ms. Bledsoe. Are you familiar with the penalties for perjury in this state?
No.
Okay. So if I was to tell you that it's a felony, 3 years in prison and a $10,000 fine, would you have reason to disagree with me?
Yes. I'd have to research it myself.
Okay. But we can agree that it is a crime in this state to
Yes.
perjure yourself?
Yes.
Okay. And if the video surveillance shows conduct other than what you're describing, that would be evidence of perjury, would it not?
Objection, that's for the fact finder to determine.
That's a finding of fact. I'm going to sustain that objection.
Okay. At this point, Judge, no further questions, but he is subject to recall.
Just a few, Your Honor, if I may. Mr. Major, do you still have Defendant's Exhibit 1?
I have not, it was given back.
Bailiff, may the witness please have that?
Okay.
Anywhere in this document, does it say Mr. Cook cannot fax a request in?
I did not read that in this.
Does it say that he can't have someone else deliver it?
It does not.
Does it say to cuss the clerk out before you make the request?
It does not.
Does it say to make the request on stolen paper with a stolen pen?
It does not.
And you were asked earlier what he was doing with the paper and pen. The answer is he was stealing it, right?
That's correct.
Okay, no further questions.
Mr. Crook, any response? Regarding the questions asked by the prosecutor here.
If a person has a right to make a public records request, and they don't have the means by which to do so on them, meaning paper and a pen, is it reasonable to assume that they would need a piece of paper and a pen to write down their public records request?
Yes.
Okay. And do you think that it is, in some way, shape, or form, theft if somebody comes in to make a public records request, they say, I don't have a piece of paper and a pen, I'm going to use a piece of paper and a pen that I found right here and write down my public records request. Is that theft, or is that them trying to, with the best of what they have on their person, to make the public records request?
That's theft.
Okay. Even though access to public records and requesting a public record is a right in the state.
Stealing paper is not, but a request is.
Do you know why the charge of theft was dismissed in?
I have no idea.
Okay. Nothing further, subject to recall.
Nothing further, Your Honor.
You may step down.
Thank you.
Your Honor, the state rests.
All right, at this time, Mr. Cook, the state has rested. I don't know what evidence, if any, you wish to present. That's totally up to you, but how do you wish to proceed with this?
The video files that I've submitted, I'd like to submit them.
In order Are you going to stipulate the authentication of this, Mr.?
No, Your Honor.
Pardon?
No, Your Honor.
You're going to have to, Mr. Cook, in some way authenticate the video that you wish to be played as being accurate, hasn't been in any way altered. And I don't know
They're all in their original format as they were given to me by the
Okay.
prosecutor's office.
Well, in order for you to do that, I believe you're going to have to be placed under oath and provide some testimony and be subject to cross-examination by Mr. Ashworth regarding this. And I think I think we'll do that as basically a voir dire kind of thing. So if you can stay where you are, you don't have to come up to the witness stand. But if you would raise your right hand to be sworn.
You solemnly swear that the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Now, for the record, would you state your name
Philip Anthony Cook,
and your address?
8 County Road 120 South, Apartment A, South Point, Ohio 45680.
All right. And you have a video, I take it, that you wish to be played. That would be,
I have several videos, Judge.
okay, are they all on one thumb drive?
Mm-hmm.
And I take it that thumb drive would be Defense Exhibit 3, is that correct?
Unless the individual files would be labeled 3, 4, 5, 6, 7, whatever.
How many videos are there?
I'm not 100% sure. I don't have, it's like 7 or 8.
How long are they?
Some of them are very long, are very long. However, I do have timestamps where the relevant information is in the video surveillance, in the video files.
And how did you obtain these videos?
They were given to my attorney, my former attorney, Mr. Morford, and I was able to get a copy from him.
All right. And okay, what are the dates of these videos?
Most of them are from December 20th, okay? And then there are a few videos of me recording phone conversations with certain people in this building that gives additional information, and I've identified those. When I made the phone calls, I stated date and time, calling this person, yada, yada, yada.
Well, do you mean December the 9th or December the 20th?
That's December 9th, sorry.
Okay, so first of all, I've never been provided any videos of phone calls. Obviously, I'm going to object and move to exclude those. I have to be provided evidence, just like, you know, he's asked for evidence, so I've never seen those. As far as the December 9th videos go, I'm not going to push him too hard on this, but I don't understand, and maybe I should voir dire.
Yeah, why don't you voir dire Mr. Cook regarding, I'm most concerned about the video of December 9th. That's probably the most relevant piece of evidence we have, that you have, that anybody has.
There are actually several videos of December 9th because there are several different camera angles of what transpired on that day.
Yeah, that was my question. So there are multiple videos of December the 9th when you are in the courtroom, excuse me, the courthouse.
Yes, and they are watermarked by them with date and time.
By who?
By the court.
Who at the court?
The files were presented to me, so typical.
Well, you said, wait a second, you said the files were presented to Mr. Mulford, correct?
They were given to Mr. Mulford on a thumb drive,
Okay,
and then I got a copy from him.
okay. So is Mr. Mulford going to testify today?
Mr. Who?
Mulford, will he testify today on the chain of custody of these videos?
No, I guess.
Did the timestamp, did you put the timestamp on there?
No,
Who
no.
put the timestamp on the videos?
That was done by the court, so if I could go up.
In other words, when you got the video, it had a timestamp on it.
Yes, and.
You don't know if the court put it on there or if the system put it on there, but you're saying you did not put it.
The system itself would have included.
What system was it?
Their video surveillance.
I mean, is it a Xerox, Canon, Minolta?
I don't know that.
Where are the angles of the videos? Are there cameras out here that correspond to the videos, I take it?
Yes, absolutely.
All right, so let me start, I guess let me do this. One, as to any videos that are not from December 9th, will you admit and agree to the court that you've never provided those to me, correct?
That's correct.
Okay. As to the December 9th videos, you will admit that you came into possession of those directly through Mr. Mulford and no other means?
That's correct, yes.
Okay, all right. No further void air questions right now, Your Honor. I would move to obviously exclude the ones that were produced, and I'm not trying to be difficult, but he does have a background in, from my understanding, in some military, I won't say intelligence, that's an oxymoron, I understand, but, and I'm certainly not here to accuse him of manipulating these videos, but I don't think there's enough here to verify they haven't been manipulated. And I think that's the concern I would have before I just laissez-faire say I don't object to these, because I think I don't see enough proof of authentication, yet to allow me to just waive that objection.
Mr. Cook?
Well, number one, they're being presented in and of themselves, but also they're being presented to impeach the testimony of the previous witnesses that came before the court, which that is a rule by which I don't have to present these to him because they're being brought to impeach direct testimony that was presented by witnesses.
That's not how that works.
That's not how discovery
Okay.
works under Criminal Rule 16, Mr. Cook.
Okay, well, I also have an audio recording of a conversation with a court official in here where that court official who is responsible for having presented and provided all of the evidence in this case to Mr. Ashworth, with that person telling me that the video surveillance was in fact presented to him.
Well, call a witness. I mean, you didn't produce that either, and I'm telling you under oath as an officer of the court, the 20-year completely clean record and a completely clean military record with accommodations and awards that I've never gotten the video, so I'm not lying about it. And I'm not trying to uphold it, objections to stifle his case, but I still have to make sure as the counsel for the state that they're authenticated.
Okay, and if the court will allow me to present them, I can call witnesses to authenticate those videos after the fact. I can recall.
Wouldn't it make sense, Mr. Cook, to call the witness who can authenticate?
Well, there are two witnesses. One is Mr. John Major, which I wish to call after the video surveillance is played, but I can call Mr. Cooper to the stand and he can authenticate the videos.
Mr. Ashworth?
He can call, I think he can call whoever he wants to. It's his case in chief.
Okay.
We'll have to make sure that, Mr. Cooper can do the things that he's representing to the court that he can do. But if he can verify, that's fine.
Okay, would you like to call Mr. Cooper?
Yes, please.
All right.
Mr. Cooper, do you solemnly swear that the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
And you may proceed.
Mr. Cooper, what is your role here at the Lawrence County Municipal Court?
Bailiff/community service director.
Okay, and are you familiar with the video recording system in this building?
Not really.
Not really. Can you identify for us, can you tell us, is there a camera in the clerk's office?
Yes.
Okay. Is there a camera in the lobby?
Yes.
Okay. Are you aware whether or not the videos that are recorded, if they have a system date and time stamp on them?
I'm not sure.
Okay. So you're not 100% sure if the videos, do you know what brand of system it is that? Okay.
I do not.
Have you ever watched any of these videos? Not these particular videos, but surveillance videos in the past. Have you done that?
Nothing has been recorded, no.
Okay. So you're only able to identify that there are cameras in the location of cameras.
Yes.
Okay. Is there also a camera out in front of the building?
Yes.
Okay. To the best of your knowledge, how many times have I been arrested at this building?
Objection, relevance.
What's the relevance of that?
Well, if I've only been arrested one time and it shows my arrest, then it's to be assumed that that's from the date of that is the video of this arrest.
Well, there's a big difference between authenticating an entire piece of evidence and saying that something on a piece of evidence stands for a proposition that happened on that day. We're talking about apples and oranges here. I'm trying to authenticate video, and he can't do it, obviously.
Is it possible that there's video surveillance of me being arrested on a date other than December 9th of
Object
2023?
I can't try the case for you.
I'm aware of that.
Mr. Cook.
Well,
In order to authenticate, you have to, Mr. Cooper has already indicated that he doesn't know how, he knows there's 3 cameras. And he's viewed surveillance footage, I guess, but I take it it's live footage that he's viewed. That's what I'm inferring from his testimony. That doesn't authenticate, and I don't know how rigorous Mr. Ashworth wants to be regarding authentication on this. If you think that Mr. Major would be a better witness to do that,
that's what I was just about to do, Judge.
well then,
So,
Mr. Ashworth, do you have any objection to
No,
that?
no.
Very well. Mr. Cooper, you may step down.
I'd like to call Mr. Major.
Very well.
I mean, I don't want to be an antagonist to his case. I kind of want to see the videos, frankly. AI has ruined evidence, Your Honor. I mean, you cannot trust anything. Again, for the record, not accusing Mr. Cook of anything out of the ordinary, but just it's long gone are the days when we can just say, play the tape.
No, I understand. But Mr. Major, if you resume the stand,
Yes, sir.
witness stand, and Mr. Cook, you may proceed.
What brand of video surveillance does this courthouse use?
Revo.
I'm sorry,
Revo,
can you spell that?
R-E-V-O.
Okay. And are there cameras in the clerk's office,
Yes,
lobby,
yes,
outside the front door?
yes.
Okay. Do those videos does the system put any kind of metadata in the video itself?
I'm sorry?
Metadata.
What do you mean by that?
That I was just about
Okay,
to
I'm
explain.
sorry.
If you're looking at a recording of something that transpired,
Okay.
not live, but recorded, Is there information in the video that's not part of the video itself, such as date and time,
Yes,
location, camera,
I think it's camera, not
camera,
location.
camera number, okay? So you can positively identify videos that were recorded by this system, correct?
Yes,
Okay. And have I been arrested once or more than once at this courthouse? To the best of your knowledge?
that's my knowledge once.
Okay, so if I show videos that show my arrest, it's legitimate to infer that that is from that date?
Objection, speculation. He's got to see the videos to authenticate them.
That's fine. If we can go ahead and play what I labeled Defense Exhibit A.
Or you have this defense exhibit, it's part of defense exhibit 3, which you're calling,
I had it pre-labeled, I labeled it because the,
okay, we'll make it exhibit 3A.
that's fine.
Say, we're correct?
Yes. Now, these do not have audio, do they?
That will not play.
It's your file.
No, wait a second. It's your file.
It was directly copied from their files.
Well, that one will not play.
May I try?
Yeah, sure.
There you go. Okay. Pause. Okay.
Wait a second.
Up.
What are the words that came up on the bottom? It said Defense Exhibit A actually on the video.
Right, I added that to the title of the video. I'm getting ready to positively identify the video itself.
So you've added things to the video.
I've only added to the title of the video. Okay, so that they can be easily identified because the original name for the videos are ridiculously long. How to make that clear? That is the name of the video right there.
I understand. I mean the thing that came up on the screen itself. When you started playing that,
When you
it
started
said,
the video, there was something that was, go back to the very beginning of the video and pause it. Pause.
right there.
That's just the name, that's not embedded, it's just.
So you're saying if you change the file name on the other program you were in, the File Explorer, it's going to show that?
No. It doesn't say that, it just said, okay, if you open a Word document, it'll show you, you've opened this Word document and the full title of it, okay? So the rest of the video does not have,
That, okay, let me ask you this. That word, those words that came up on the bottom of that screen match the thing that's in the display bar when you clicked on it before you played it?
right there.
Those are the same thing?
Yep,
And that's where it's drawing that information
Yes.
from? Okay, very good.
well, where did it go? Before you begin, is there a sign outside of the clerk's office that says only one person at a time?
Yes.
Okay. Go ahead and watch the video. Sorry.
It's playing behind you as well.
All right. Well, I figured without his eyesight, it might be easier to read that one. What is that? Did you see that?
It's a cat coming in.
Okay. Really quickly. Crap, sorry. I do not like the DLC. Can you see
Mm-hmm.
do you see right there?
It appears to be Mr. Morford, I don't know who the other person is.
Okay. So is it common for Mr. Morford to have conversations with his client right there?
I couldn't say, I know he does, but I don't know if it's common.
Okay, but he does that.
He does.
And it would be reasonable to assume that had I committed created a commotion, that he might have been stirred.
Objects to forms, calls for speculation about what Mr. Mulford would do.
That's a speculative answer.
And we can agree that this is the camera inside of the clerk's office,
That's correct.
facing out towards the law.
That is correct.
Okay. And you have no concern over the authenticity of the video?
And as of right now, no.
Okay. I'm going to direct your attention to right here.
I've already seen it. There's no Richard. Yes, you just came through.
And I'm standing right here,
You are.
okay? Why might I be doing that?
Because Mr. Morford's in the area where you want to go.
And there's a sign that says,
Yes.
okay. Do you know what I'm doing right here?
I have no idea.
I'm trying to let the cat out.
Okay.
What just happened right there?
You entered the clerk's office to the public area.
Was I waved in?
I really didn't look, but, you know, if you play it back, I wasn't watching anybody waving in.
Well, now it sees other videos. Judge, if it's okay with you, I'd like to watch it all the way through because I think that jumping around is causing us some problems.
That's fine. Let's get it over with.
So, person about the, right here,
Mhm.
wait a minute, yes?
Her hand tested something, yes, and you came in.
Okay. Do I seem agitated at this point?
No.
Fairly calm, yes?
Mhm.
At this point, she is calling over one of her coworkers. Did you see her motion from,
Okay,
because she didn't know how to handle my request?
okay.
Calling somebody else over?
Okay.
What does it appear that I'm doing right there?
Talking to me, apparently.
Okay, but I want to ask you a question about the plexiglass that's right there, okay? So the plexiglass is about this high up off the counter, correct?
Yeah,
And there are holes in the plexiglass to be able to speak through, right?
yes.
Did you see me bend down?
Mm-hmm.
Why do you think I did that?
I have no idea.
Do you think I'd bend down like that if I was yelling and screaming? Or maybe I was trying not to disturb Mr. Morphy?
Okay.
Is that a potential possibility?
Objective form speculation.
That is an incorrect form to ask the question, Mr. Coach.
At this point, have you seen me do anything disorderly?
No.
Am I agitated at this point?
No.
What I'm asking you to do is, I want you to point to the moment you said that I became disorderly,
If you can.
if possible. And I want you to state what behavior you witnessed that was disorderly.
Well, I object. You ask the questions appropriately.
Yeah. That's not the proper way to ask the question.
Would you indicate, when you see me become disorderly, and would you indicate what behavior you witnessed that was disorderly? When you see it?
Objective form, multiple questions, it's not appropriate to tell him to watch the whole video.
Still calm.
Yes.
bending over and leaning on the counter, correct?
I can't see you from Ms. Bledsoe.
But you've not witnessed anything disorderly at this point, correct or no?
Wait, what?
Have you witnessed anything disorderly?
I can't see you, so, from this angle. From this angle, you're starting to be more animated. Your head's moving more. I can't see your movements, and you can't see your body language from this angle.
So
you're becoming more agitated at this point. I'm not going to say you're disorderly, but you're more agitated.
nodding up and down, acknowledging what somebody says is disorderly. Or
Objection, he can testify however he wants, sir. If you don't like it, that's your problem. But don't put words in his mouth.
So they're leaning on the counter again.
Okay?
Still look disorderly or agitated, as you put
He's
it?
already testified that you are, sir.
Now, that was really interesting just now. Did you witness that?
So,
Mr. Cooper?
Cooper left? Yes, I saw Mr. Cooper leave.
Okay. Do you think he would have left if he witnessed me doing some kind of,
Mr. Cooper is not a law enforcement officer.
he's a bailiff in this courthouse?
Objection calls for speculation about what Mr. Cooper would do.
I'm not sustaining the objection. Let's play the video. Keep playing the video.
Your demeanor has changed, your stance has changed. Those are all body language indicators that you're becoming more agitated. Again, I know your head's moving more than before. You're becoming more agitated.
So, I want to go back just a second ago. You said that me moving around and is signs of agitation.
In my training.
Okay. You're not aware of my medical conditions, are you?
No.
Okay. If somebody has a bad back, can they, would it be reasonable to assume that somebody with a bad back standing on a hard surface might kind of shuffle around a little bit because of stressors on their back? Do you have a bad back?
I do not.
You do not. Is that, have you ever known somebody with a bad back that kind of?
I would be speculating to the I'm not a medical doctor.
Okay. But you still have more reading ability.
I have not.
Seem to be pretty calm.
Are you testifying, sir, or are you asking a question?
Do you see agitation? Do you see animation?
Well, from this angle, you can't see everything you're doing. From my perspective where I'm standing,
Am I moving around?
you are.
I'm moving around right now.
You're swaying, your body language, it's all taken into perspective. Head movements, hand movements.
Does it appear by the actions of other individuals in the video, are they taking any kind of notice of me? Are they, you know, somebody just came in with looked like a hamburger and left. Anybody taking any notice of me or what I'm doing other than the three of us?
Objection, speculation, objection, compound question.
Do you see anybody taking notice of me or our conversation?
There's nobody in the screen at this time.
But if I was being agitated, if I was yelling, if I was cussing, if I was doing any of those things, it might arouse the attention of other individuals.
Objection, speculation.
Again, I'm going to sustain the objection. He can't testify to that.
You're increasingly getting more agitated due to your movement of your body, your head, hands.
Excuse me.
Due to my body language, I just took more of an attentive stance towards you. You're becoming now even more agitated. You can tell by you're moving around, your head bobbing. Becoming more agitated, more animated.
Are people allowed to disagree with the people in the clerk's office?
Of course. I mean, more agitated and the hands are moving more. Your body language has changed. Your not really paying the swaying.
Did you just catch that?
And I mean, you were talking.
Don't stop it if you're just gonna skip it around. This is long enough.
This is where
You missed it. You just pointed for me to leave the building. You missed it.
okay. I do point to for you to move the building.
But
Leave the building.
you missed the moment in the video when you pointed for me to leave the
Okay.
building. Okay? I'm not being disorderly. There's nothing here. If this is disorderly,
I've already advised you. If I've told you to leave the building, I've already advised you to cease and desist your disorderly actions. And now you're even becoming more agitated.
do you recall me asking you if I was being disorderly because of my use of profanity?
No, do not. And now you
Do not stop it. For best evidence rule, play the whole thing through.
Okay.
believe you just entered back into the building. I haven't noticed you yet.
But if I was being disorderly, if I was, talking at the top of my lungs.
Are you testifying, Mr. Cook, or are you asking?
I'm asking a question.
Well, then ask a question, don't, that,
Would you have noticed me sooner if I was?
I have my back towards you. You left the building, I didn't expect you to come back.
And how long did you witness me be gone for?
I don't know. A minute?
Could have been less than 30 seconds.
The record will reflect the video is however long it is.
But at this point, you've already declared me to be disorderly.
No, I've not arrested you for disorderly
No,
conduct.
no, no, I didn't say arrested me. You've already declared me to be disorderly.
No, I've advised you to stop being disorderly.
True or false, you said, leave the building or I will arrest you for being disorderly right now.
I do not remember that statement. I remember telling you to cease and desist, and I told you to leave the building.
And if I didn't leave the building, what were you going to
You're
do?
going to arrest, that wasn't for disorderly. That'd be trespassing.
Okay, are you aware that without a valid criminal act on a public property, such as a building, such as a courthouse, you cannot trespass somebody?
That's your opinion.
It's well
It'd be
established
up
law.
to, I advised you to leave. You were causing a disturbance, I advised you to leave.
Sorry, but if, well, I'm withdrawing.
Have you been taken into custody at this point?
No.
No, not yet.
Now you're going to arrest me.
Correct.
I'm going to close this out because there's nothing probative left, unless the prosecutor wants to see.
No, that's it, that's fine. Well, let me help you out.
Well, hang on a second. hang on.
Well, you need to authenticate it so we can admit it into evidence.
Okay, all right. So, you agree that this is from, Are your cameras, there's a date and timestamp there that says September 12th, 2024.
Okay.
Are your cameras accurate on the date and
I
timestamp?
don't have access to the, to that type of,
Okay,
pro, so if it's, I don't know if it's accurate or not.
okay. I'll look back at the file really quickly.
But I will testify that that is the correct, video for that day.
Okay,
For
so,
the date that you were.
Yeah, let's stipulate it's December the 9th, so we don't get too confused
Sure.
about it.
It'll be stipulated.
okay. And I've only been arrested once at this courthouse.
Yes,
Okay, so this is an accurate representation of what happened on December 9th, 2024 in this courthouse.
that is a video representation of it, yes.
Yes. Okay. Does it appear to be modified in any way, shape, or form? Does it choke around? Is it herky-jerky?
Not in my opinion,
So, in your opinion, has this been modified or molested?
not in my opinion.
Okay. Are you satisfied?
Yeah, that sounds good. That's a true and accurate copy of the video as you recall it to be.
That is, yes, sir.
Okay.
Okay. So, we're gonna go to C because this is a really short one. Again, the date and timestamp is incorrect.
For the record, we're at defendants 3, now C, 3C.
Yes, just because of brevity.
And I stipulate, well, I guess I stipulate this is, looks like December the 9th of 2024.
Is this an accurate representation of what transpired?
It is.
Okay. And what are you doing at this point?
I'm taking you to the holding cell.
Okay.
Judge, before I go into B and D, because they are longer, I wonder if we might take a 2-minute recess?
Do they add anything that we haven't seen?
Yes,
Okay.
they do.
Very good.
All right, let's take a 10-minute recess. Normally I would break for lunch, but I think it's much better. Let's just get this.
And that's all I have, more than maybe a
Okay.
15-minute recess.
Do you have witnesses, sir, if I may ask, other than him? Okay. Are you calling yourself to testify?
Come on, hang on a second. I gotta go to the restroom. I apologize for the...
Are we off the record, Your Honor? Are we off the record, Your Honor?
We're off the record. We're off the record. You are now off the record.
May I be excused?
You may be excused. Mr. Clerk,
May I
you
be
may
excused?
I'm just going to sit here.
Judge, does Mr. Major need to remain at the witness stand, or can he take a recess?
No, he can't take a break.
I'm good.
You're good?
Yep. I'm
Me
good.
too.
Thank you.
And that long drive ahead of you.
Yes, sir.
I believe you're a sequestered witness, so you can't do anything.
I better stand up. I'm starting to cramp up.
Are you going to reject me playing a YouTube video?
I'm sorry,
Are you going to reject me playing a YouTube video?
which one is it?
It's not here. That was what I wanted.
Is it from December the 9th?
No, it's from a case.
What's the point of it?
Because the Sixth Circuit Court of Appeals denied qualified immunity for somebody who was arrested for disorderly conduct, far more egregious than anything in this.
What's it gonna do with your case, though?
It establishes.
Qualified immunity is a civil issue for
Right, but-
1983, actually.
Well, right, but clearly established rights.
Yeah, I'm objecting to it. I just don't want to waste any more time, man. Let's get going. How long are these other two videos?
They're pretty long. I didn't want to break them up because didn't want to be accused of tampering. I'm going to go ahead and queue up the next video.
Lawrence County Municipal Court's now back in session.
Please be seated. Just back on record.
Are we back on the record?
Let's go back on the record.
We are now back on the record, Your Honor.
Thank you. This is a reduction of the matter of the State of Ohio versus Philip Cook. It's 24 CRB 1, I think it's, what is that, 117 or 781. Can't read my own writing. You may proceed, Mr. Clerk.
Going to play Exhibit B, continuing with video surveillance, is that
Your Exhibit 3B?
3, this would be 3B, yes.
Okay.
Okay. Is this an accurate portrayal of the entryway of the courthouse?
Yes.
Okay. And right in front of you is a security desk, yes?
Yes.
Okay. And the clerk's office is off to your right? Yes? Okay.
Mr. Cook, is the time stamp that's purported up there correct?
No, it is not, Judge, my apologies. Can we agree that despite the timestamp on video, that this is, well,
You may have to see more of it.
yeah, when we get to certain parts of it, we'll be able to clearly identify that this is of the same interaction. At this point, you don't have any concerns.
I do not.
Mr. Ashworth, do you have any concerns?
No, sir, it's fine to me. I'll stipulate if it's the same day. What's D? What's D?
It is, I believe it is shown from the same area, but into the actual clerk's office.
Gotcha.
So, reverse view of the first.
Makes sense, yeah.
Unless you want to stipulate there was no disorderly. That's fine. My apologies, Judge, I don't want to jump forward because I don't want to script the video, this is fairly long. 21 minutes. Judge, may I ask you a couple questions while we're waiting for?
Absolutely.
Okay. You testified to what you thought I was doing that was disorderly. Agreed?
Okay, yes.
Okay. I want to ask you a couple of questions. You made the mention of moving around, not being able to stand still, talking with your hands. These are all indicators of disorderly conduct.
Check the form.
That's-
Do you agree that these are what you testified to as
From the beginning of the time you came in the clerk's office to the time that, yes.
I'm talking about in a broader scope of, are these behaviors that you equate with being disorderly?
Check the form. Holistically, I don't understand what we're doing here. His testimony is what it is, sir. You don't get to piecemeal it out.
Well, he has to have a general idea of what he believes is disorderly.
He's testified to that.
Right.
You leave stuff out, you don't get to frame it up like that. That's a misrepresentation of evidence. You didn't talk about vulgarity, you didn't talk about any of the other things he said. If you want to reflect everything he said and ask him, that's fine, but don't pick what you want. I object to that.
Would you agree that throwing things might be considered disorderly?
Yes.
Okay. There I am leaving.
Correct.
And that's 4527. Coming back to 4526.
Okay.
So I was gone for less than 20 seconds.
Okay.
Agreed or not?
That's what the video shows.
Did I reach around the backside of the security desk?
You did not.
Okay. If there were weapons kept there, would they be on the backside or the front side?
They're kept around that area. There's holes on both sides, so they're accessible from both sides. And for clarification, weapons we've taken from people bringing them to the courthouse that day.
So not security weapons?
No.
Is there any way for me to know if there's confiscated weapons on that day?
Wouldn't know.
Do I appear to be agitated?
Not this time.
Recall. Agreed?
You're writing something. I don't know what your mental state is.
I'm not asking about mental state. I'm talking about conduct. Is my conduct in any way, shape, or form disorderly at this point?
I would not arrest you for disorderly conduct this time, no.
Now you're coming back into the frame.
Mhm.
You appear to be moving around quite a bit.
Mhm.
Mr. Ashford.
Sir,
I'd like to see.
I don't want to watch it. I'll watch it if I want to. Tell me what to do.
Pacing around. Throwing things. You appear to be far more agitated and angry than I was at any point.
You're testifying here, Mr. Cook. Do you have a
Mr.
question?
Major, yes or no? You were angry, weren't you?
I was not.
You weren't.
I was not.
Okay. And did you see yourself throw that piece of paper?
No, I did not. It was blocked. My hands were blocked by the metal detector.
Okay. You'll see that in the next video. I placed the piece of paper, true or false, I placed a piece of paper on the desk, turned and walked out.
You did not. You handed it to me.
No. But, because that's all that's probative in this video, I'm gonna try and rewind it so that we can see that last part. Apparently it's not gonna let me go back. But you didn't see anything disorderly there.
Objective form.
Did you see anything disorderly there?
No.
Okay. Then how do you justify my conduct here was no different than what was in the clerk's office? How do you justify,
Objection. The objection will be sustained.
do you see a significant difference in conduct between me here and me in the clerk's office?
Yes.
What is that?
your demeanor. You're standing there writing in the clerk's office, you're being loud, you're being moving around, your head's moving around, your body language is changing, you're agitated. There you're writing on a piece of paper. That is the difference.
You said that I was being loud, but nobody other than in the clerk's office, you said I was being loud, but nobody took any kind of, did you see anybody in the video take any special notice of me or our conversation that might be attributed to a loud conversation?
Object to form, calls for speculation.
I'm going to have to say,
Withdraw. You appear to be very agitated in this.
Okay.
Withdraw, withdraw. Now, I want you to pay close attention when I put the piece of paper down and I turn around and leave. Do you recall me saying anything to you in that moment?
Nope,
You don't recall me saying, make sure the judge gets this?
I don't remember that.
If I was to tell you that I said, give this, make sure the judge get this, would you have reason to say I was wrong?
I would not.
Okay. Oh, no, my fault. So that's all the video surveillance that I have. That's all the video from that day.
I thought there was this other one.
I thought I must have grabbed the wrong video.
Okay.
so you have A, B, and C
Right.
as part of Exhibit D.
Yes, sir.
Exhibit 3, rather. Okay. Do you have any objection to those being authentic? Mr.
I do not.
Very well. Do you have any more questions, Mr. Mayor? Major?
When we watched the video in the court, or in the clerk's office, the first video,
Yes.
did you see anything that was abnormal for a normal conversation?
Yes, your body language.
Is my body language today any different than it was on that day?
Yes.
Really, how?
You're not as animated as you were in the clerk's office. You're stamping your hands down, you're not bobbing your head, you're not,
I'm rocking on my feet.
not bobbing your head.
Nothing further at this time, Judge.
Mr. Ashworth, do you have any questions?
Briefly, Your Honor, but it won't take long. So the first thing I observed, confirm for me if this is correct, that video in the clerk's office window was like, what, 30 minutes long? He stood there for 30 minutes, is that accurate? And you were what, 3 feet away from him?
If that.
If that. There's no video, or excuse me, there's no audio that accompanies any of these videos, is that accurate?
Our system does not record audio.
And is there anything that you saw on the stuff that you watched that you believe you should change any of the prior testimony that you gave under your direct examination earlier?
I do not.
But nevertheless, that video that's 33 minutes long does show him asked to leave and return, then ruffle through the security portal before you went back out and interacted with him again.
Correct.
He trespassed, he took property. Would it be safe to say that what I see in the video is you having restraint?
Yes.
Okay, no further questions.
Redirect, Judge. Without a lawful command to leave, that there cannot be a criminal trespass.
I advise you to leave.
That's not my question. I asked you, and I'm going to repeat it. Are you aware that without a lawful command to leave, there cannot be a criminal trespass?
I ordered you to leave.
It's not the question. Judge, I'm going to ask you to instruct him to answer.
I don't understand the question, Your Honor.
And his testimony stands as it is. I'm not sure what you're asking here.
I'm trying to get to the concept of lawful orders versus unlawful orders, Judge.
I think it's your call, Your Honor.
Look, I'm the finder of fact here this afternoon. I've heard testimony. I can hear your testimony if you wish to do that. He's already testified as to what he said, so let's just move it along.
If somebody comes in wearing a red shirt, can you order them to leave the building?
Objection outside the scope of cross-examination.
That is outside the scope of what was asked.
Nothing further at this time, Judge.
No further questions.
You may step down.
This witness, I think, can be released, Your Honor.
Very well.
I would like to recall Mr. Cooper.
Very well.
Back up there.
Mr. Cooper, as you are still under oath, and please be seated. Mr. Cook, you may proceed.
Mr. Cooper, do you recall the events that transpired on December 9th, 2024?
A little bit about it, yeah.
Okay. Present in the clerk's office and then outside of the clerk's office at the security desk. You were in the immediate vicinity pretty much the entire time, correct?
No. To my recollection, that was a court day, and I was in the courtroom, and then I may have took some paperwork to the clerk's office that day, and then I met you all in the lobby.
Okay, so you don't recall being in the clerk's office for a significant
No.
period of time? Okay.
No.
Well, let me ask you this. Did you ever hear me on that day raise my voice?
No.
So while you were in the clerk's office, at the security desk, while you were in the courtroom, you never heard me raise my voice?
Not in the clerk's office, not to my recollection, no, I do not.
So, if somebody was to have said previously in testimony that I was being loud and creating a commotion verbally, that's not the experience that you had on that day, correct?
Not me, no.
Okay. Are you OPATA certified?
No,
So you've not been to any kind of police academy or anything like that?
no.
Okay. Do you know, do you have arrest powers?
Yes,
Okay. Do you understand the like, what is and is not disorderly conduct?
yes,
Okay. Based on your interactions in the clerk's office and at the security desk on that day, everything that you recall, can you point to any point at which I was loud, creating a disturbance, being disorderly, causing attention to be drawn to me from other people?
like I said, I don't really remember, I didn't see anything, observe anything in the clerk's office. I did not see anything in there.
But you were not there the entire time, agreed?
Yes, I agree.
Okay, but again, let me ask you this. Have you ever heard me raise my voice?
Yes, I have.
When was that?
You raised your voice when you came into your last court hearing out here with me. At the scanner. You had a seatbelt cover on you. And I advised you that you couldn't bring it in the courtroom, and you said it was a seatbelt cover.
Mm-hmm. But I didn't raise my,
Yes, you did.
okay, well, was I being disorderly in that conversation?
Not at that time, no.
Okay. Is that the only time you've ever heard me raise my voice?
Yeah.
Okay. Pretty calm and collected person, agreed?
From my recollection,
You've never had a problem with it?
I've never had a problem with it, no.
Nothing further at this time.
No questions, Your Honor.
All right, you may sit down. Mr. Clerk?
Judge, he asked me if I was going to be taking the stand. If he wants to ask me questions, I'd be happy to answer them.
He can testify if he wants to. I'll cross-examine him if he testifies.
Do you wish to testify?
I don't think it's necessary at this point, Judge.
Very well. So I take it you want the 3 exhibits, Exhibit 1, 2, and 3, A, B, and C to be admitted into evidence?
Yes, Judge.
Is there any objection, Mr. Ashworth?
No, Your Honor, I think no objection to any of the exhibits at all.
Okay. Defense Exhibits 1, 2, and 3 will be admitted. Any rebuttal testimony, Mr. Ashworth?
No, Your Honor.
Very well. Closing argument, Mr. Ashworth.
Yes, Your Honor. Briefly, I think those videos pretty much prove what we needed to prove. He came in for 30 minutes. He argued with the clerk's office. It's undisputed at this point that he used some type of vulgarity. He says, hell, they say bullshit, whatever. You don't do that to a clerk, especially when they're trying to help you out. He did that. He was approached by security. It looked like they gave him every benefit of the doubt for 33 minutes. We watched the video. As he sat there, he became aggravated. Mr. Major was a few feet away from him with 27 years of law enforcement experience. He testified pretty unequivocally that Mr. Cook was agitated. He was causing a commotion. And then, on top of all of that, he leaves the building, being requested to do so, and then returns. He is technically trespassing, and then rummages through material that he knows for certain is not something that he should be rummaging through. So what I would ask the court to do holistically is to look at all of these facts and then look at the State versus Jackson case. This is clear. Tumultuous behavior. If I've proven beyond a reasonable doubt that there was unruly conduct that was characterized by a commotion, if the facts establish that, then he is guilty of a violation of 291711A1. So that's tumultuous behavior. It's the same thing. Vulgarity in and of itself, I agree, that standing alone is not necessarily disorderly conduct, but when you couple that with technical trespass, even though I didn't charge him with that because we see more restraint than he certainly gives anybody credit for. They gave him an opportunity to rummage through that desk. They gave him an opportunity to cuss at the clerk. And now he's trying to use that to suggest he didn't do anything wrong. Well, clearly, he caused a commotion and he was unruly. He was guilty of disorderly conduct, and the evidence shows that. Thank you, Your Honor.
All right, thank you, Mr. Cook.
Judge, if that's disorderly, then any normal conversation between two or more people is disorderly. Number one, the only thing that they can point to is the fact that I shuffled my feet or swayed back and forth. I happen to have a bad back. That 9.5 years in the Army, I've got a bad back. I move periodically.
Move to strike, that evidence is not in play, Your Honor.
People with medical conditions sway back and forth all the time. There is zero evidence of disorderly conduct. That was a cool, calm, collected conversation where the use of one foul word cannot be disorderly, and the video surveillance shows that there was no conduct that was in any way, shape, or form creating a commotion to attract attention or do anything of that nature. I was quite calm, and I would say that if, and this is why I wish to bring Mr. Morford forward to present to testify, if I was being loud and obnoxious and causing a commotion, the people that were in the clerk's office would have taken notice of that. The other people who worked in the clerk's office who were present, I pointed to the one lady who was walking around with a hamburger, would have taken notice. Nobody took notice to it. Mr. Cooper testified himself that he never heard me get loud. He never heard me raise my voice. And there's just far too much evidence to the contrary that I committed any kind of criminal act.
Any rebuttal?
No, Your Honor.
Very well. Well, this thing's gone on for quite a while, frankly. And, 291711 reads, and I think this is the section that we may be under. No person shall recklessly cause inconvenience and no answer alarm to another by doing any of the following: making an unreasonable noise or an offensively coarse utterance, gesture, or display of communicating unwarranted or grossly abusive language to any person. You know, it appears both Ms. Bledsoe and Ms. Major have testified that this was offensive to them. They asked you to leave. Now, I don't see why, I understand why they may have, I think they were charged with theft, frankly. It was probably an unauthorized use of property. You didn't ask anybody if you could write a letter to the judge, to Judge Capper. And based on what the video shows, I think it corroborates what both Ms. Bledsoe and Mr. Major have testified to. I'm going to find you guilty of disorderly conduct here. Now, as you know, the maximum penalty is $150 for court costs. Is there anything you'd like to state to the court?
Yes, I will be appealing the decision.
Absolutely, you're right.
The Supreme Court has repeatedly ruled that offensive language is not justification for disorderly conduct. That violates Supreme Court precedent dating back decades.
Well, that's not exactly the law, Mr. Cook, and I'm not here to argue the law. Perhaps those three judges on the, I believe, on the 4th District Court of Appeals will find that what my decision is inappropriate. They can overrule me, and believe me, I've been reversed before. So, but do you have anything to state regarding punishment in this matter?
I'm indigent. I'm a disabled combat vet, and I live on my VA disability.
All right. In that case, I'm going to make it a $50 fine in court costs. Now, there was Mr. Ashworth, you had asked this court for sanctions. You filed a motion for sanctions. And I believe that was filed on November 17th of 2025.
Yes, Your Honor.
Do you wish to address that?
I do. I will maintain that. What we saw on this was egregious misuse of the court's time and resources. There was significant motion practice that was completely unnecessary after several warnings. And the fact that I'm even here was the result of efforts made to basically file complaints against everyone that's involved in this. The commissioners have now been required to pay a bunch of money that they frankly shouldn't have paid. There's going to be an appeal. I'll have to ask the court to extend my special prosecutor appointment to this case so that I can address the appeal. And we are going to spend more money on something that's clear. It's disorderly conduct. I should have maintained the theft and trespass charges. Of course, he has absolute no ability to reflect upon his own actions, and that's a problem.
Mr. Cook, anything that you'd like to say regarding that?
No.
Okay. Mr. Ashworth, I'm not going to rule on that. I'm going to defer, if this is going to be appealed, I'm going to defer to the Court of Appeals. They'll have the entire record here, Mr. Cook, and they can determine whether or not the conduct you've engaged in would allow for some type of sanctions to be imposed. I think you did file a bunch of things that didn't need to be filed. I'll be honest with you. I think you looked at a lot of things. I suspect, speaking of AI, I suspect you used AI in order to, well, maybe you didn't. I don't know. And I'm not going to say you did. But what I am going to say is you're not a lawyer. You know that. I know that. And a lot of the things that you filed were absolutely irrelevant to the matter here at hand. I wish you the best, but I think you need to change your attitude when you're conducting business with people. This is an old man's advice. That I see attitudes that are good, I see attitudes that are bad, and it's not, you don't get anything done if you have a bad attitude. You know, it's you get more flies with honey, or you could get it with male bovine excrement. I don't know, but I won't say the word that was allegedly said by you. So I wish you the best, but that's going to be the order of this court, and we're adjourned.
Your Honor, are we doing any type of probation?
It's not a jailable offense. Good luck, sir.
So when does the fine have to be paid?
You'll have time to pay that. It doesn't have to be paid immediately. You can start the payment plan.
How am I supposed to?
Thank you, Your Honor.
Thank you.
Okay, I need my thumb drive back.
I do, I'm sorry.
Is that the answer?
That is the answer.
Okay.
I need my thumb drive.